A federal judge says a government rule banning non-compete agreements for most workers cannot take effect. Fox 4's Alex Boyer has the story.
Hey, Steve, you know, the FTC says that these non-compete agreements really put unfair restraint on competition and also suppress workers' wages and mobility efforts. But a Dallas judge has said that even if the FTC does have the power to adopt this rule, the agency has not justified banning virtually all non-compete agreements.
U.S. District Court Judge Ada Brown, a Trump appointee, has barred a controversial Federal Trade Commission rule from taking effect on September 4th. It would have banned agreements signed by workers promising not to join their employers' rivals or start a competing business.
This is really important. I mean, this is a significant part of employment.
David Cole is a constitutional law attorney who has been following this case closely. The FTC says 30 million people, about 1 in 5 workers, are subject to a non-compete agreement. Proposed last year, supporters claimed those agreements harm workers by reducing the ability to switch jobs for higher pay. The clause spans multiple career fields, from casino workers to doctors and journalists. The Democrat-controlled FTC voted 3-2 to ban non-compete agreements. Business groups argued that Congress never intended to give the FTC those broad powers and that banning non-competes would make it difficult to safeguard trade secrets and other confidential information. On Tuesday, Judge Brown ruled that the FTC does not have the authority to ban practices it deems unfair methods of competition by adopting broad rules, saying in part the Commission's lack of evidence as to why they chose to impose such a sweeping prohibition instead of targeting specific harmful non-competes renders the rule arbitrary and capricious. Cole breaks down the thought behind her ruling.
This is not the sort of thing Congress had in mind when it created the FTC. This is an overreach. You just don't have the authority to go into this area. And this sort of argument that she adopts in this case about FTC going beyond its statutory authority is very popular these days in the courts.
And an FTC spokesperson says the agency is very disappointed with the judge's ruling and added that they are seriously considering a potential appeal. Cole tells me that if that appeal goes forward, of course, it would go to the Fifth Circuit in New Orleans, which tends to be a very conservative court. He says ultimately this case could end up before the U.S. Supreme Court.